Okay, everyone, welcome. I welcome you all to the Conditional Permanent Residency webinar, and I'd like to introduce you to our presenter, Atulya Sharman, who is a barrister and solicitor at the South Asian Legal Clinic of Ontario. So if you have questions, you can type in your questions throughout the presentation, and your questions will appear on the right-hand side of the screen right here.
Hello, everyone. Hope everyone is doing well. So my name is Atulya. Thanks for introducing me, Amy. I work as a staff lawyer at the South Asian Legal Clinic of Ontario. And today we're going to talk about the conditional permanent residence changes that has come on spousal sponsorship issues. Okay, so how does it go?
Interesting. Oh, click on. Oh, do it again now. Very good.
So I'll just speak a little bit about where I work. So the South Asian Legal Clinic of Ontario is a legal aid clinic established in the year 1999, and since 2007 we are a permanently funded ethno-specific legal clinic serving low-income South Asians across GTA. And SALCO's mandate, of course, is to provide access to justice for low-income South Asians in the province, in GTA actually. And okay, and basically we practice in different areas of law, such as immigration, which does not include refugee law. I just want to clarify that. Mostly we do humanitarian and compassionate ground applications, spousal sponsorship, and that's where you'll see a conditional permanent residence will kick in. We'll start seeing a few cases. We also practice in Ontario Disability Support Program, assist clients in their social benefits tribunal appeals for welfare, OW matters, old age security, Canada pension plan matters, as you can see the list, EI matters, some human rights cases, and some workplace safety insurance board matters. In addition to SALCO's casework, we also do quite a few public legal education on a monthly basis. And basically in these areas of law that you see on your screen, I just wanted to confirm everyone is able to hear me clearly. I guess if people can just say yes or write yes. Oh, it is cutting, no sound. We can't hear you.
Okay, sorry about that. Hello, we're just doing a quick sound test. Can you please respond if you can hear this? Okay, it looks like the sound is back okay. So we'll just move this a bit closer.
Okay.
Okay.
Okay, perfect. Thank you. Okay, so SALCO's areas of practice, as I was talking about, these specific areas of law that we work in terms of representation, summary, advice, brief services. And in addition to that, we also conduct public legal education in these areas of law. The area of law that we haven't, it's not specified here, is wills and estate, that we also do public legal education in. It's an area that we have identified a lot of seniors within the South Asian community require assistance in, and there's not a lot of information available out there. So wills and estate is something that an area that we don't practice in. We cannot make a will for someone, but we do provide public legal education matters. SALCO is also part of various law reform initiatives, such as Color Poverty Campaign. We're also part of the University of York University envisioning global human rights mechanisms, specifically focusing on LGBTQ community across the globe. In particular, we're representing India in that case, in that particular research. We also do test case work. You may have heard of the Supreme Court of Canada decision in the Whale case, and also in which was the M versus MVNS. We also intervened in the low-income cutoff case for parental sponsorship, and where the sponsorship debt recovery has happened without informing the sponsor. So we intervened in that case as well. So various areas we're involved in. We also have a project called Forced Marriages Project. Do check out our website. We encourage you to go. So let's move on to the topic today. What are we here for? It's on conditional permanent residence. As you may know, there are several plethora of changes that are coming in the recent year or so by Citizenship and Immigration in Canada. And these changes have basically changed the overall picture of our immigration and refugee system. And I think it's important to, and we're talking about a very small, minuscule part of it, but there is a bit of a sense of why these things are happening and what's the basis. We're going to keep our discussion or this presentation focused on conditional permanent residence, but I will briefly speak about the background of where this is all coming from and how did we get here. So this piece of information, that the slide that you see, is straight from the CIC website, from their backgrounder of the why conditional permanent residence is required in Canada. And as you can see, the language is very, it's really hard to understand where this is coming from. But all I can tell you, at least what I can clearly tell you, this came from our communities. There was a big lobby of our own group and community members who had essentially went after to actually change this law and to bring this in, saying that there are a lot of fraud marriages happening, a lot of marriages of convenience are happening, and I think that's where the government basically took that and essentially, for a lack of a better word, ran with it, and this is why we are here today. The unfortunate thing, or I guess rather interesting, is all this backgrounder information does not talk about the statistics. There are no statistics that we have seen how many of all legitimate sponsorships are actually fraudulent or are actually marriages of convenience. We don't know that. All we know is that there was certain vested groups that lobbied for it and rallied for it, and we have a change in law now, which is going to have serious implications on rest of the genuine relationships, genuine marriages that occur in Canada. So this actually essentially also creates a second tier system for people's for recent immigrants or people who are getting married overseas, for making them answerable to the government why your marriage is not working, why it is working, in those sense. And as you'll see throughout the presentation, you'll see how the law has made it in a way which is very unfortunate. So moving on, what part of the legislation it comes from? Section 72.1 to Section 72.4 of the Immigration Refugee Protection Regulations. It's very important to remember the distinction. There is the Act, which is the IRPA, as you may have heard of it, Immigration Refugee Protection Act, and then the nuts and bolts of the Act are always present in the regulations, and that's what we're talking about. We're talking about the IRPR, the regulations. This came into effect on October 25th, 2012. What is it though? What essentially is this conditional permanent residence is? If a spouse, common law or conjugal partner who are in a relationship with their sponsor for 2 years or less, it's very important, 2 years or less, and have no children in common with their sponsor at the time of sponsorship application, they are subjected to the conditional permanent residence. What does that mean? That means the person who is sponsored here, everything remains the same. They will get a permanent resident card, everything stays there, but they will have a condition on their permanent residence. It's in the GCMS, it's the government's notes computer system, the global case management system, that from this date onwards to 2 years onwards, this couple should be living, and I read from the slide, the condition requires the sponsored spouse or partner to cohabit in a conjugal relationship with their sponsor for a period of 2 years after the day on which they became a permanent resident. So pay attention to 4 things here: 2 years or less, no children in common, cohabit in a conjugal relationship. These 4 things are critical for this, and there are certain exceptions that the government has provided, where with consultations with certain groups, they have come up with this, and it's a welcome gesture from our side that there are at least some exceptions. If there is evidence of abuse, including physical, sexual, psychological abuse, or financial abuse, abuse could be of any kind, evidence of neglect, and failure of sponsor to protect the sponsored spouse, or death of the sponsor. In those cases, this condition will not apply. And remember one thing, it's only for applications that were sent after October 25th, 2012. That's very critical. That's the date it came into force. So how does this, so why are there exceptions? So essentially, as we all know, and you may know from your work in various agencies across Ontario, that women in particular coming here as a sponsor spouse are in a vulnerable state, vulnerable situation. And that's why a lot of groups and non-governmental organizations, community agencies, they lobbied to get this exception into the regulations, that if there is an abuse, if there is a neglect, and which already exists, and we know from our work in the communities, with this conditional permanent residence, now it is even more potent. There is a likelihood of the abuse being more potent, because the issue here now is there is an onus. The responsibility is now on the sponsored spouse to prove all this abuse, to prove the neglect, to prove the failure of protection from the sponsor, all these things, in order to protect their permanent residence status in Canada. That makes it very difficult. And so essentially, if you look at it from a different point of view, the sponsor has even more power. There was a power imbalance, and now there is even more power imbalance between the sponsor and the sponsored spouse, particularly in cases where it's a woman, where we know from our work, people have been saying, the Canadian citizens or permanent residents who have sponsored their spouses, I can get you out of this country, I can send a letter and you'll be out of this country in no time. These things have been happening when this thing didn't exist. Imagine the situation when now the act has actually changed, the law has actually changed. Now they have a paper to prove this, and they have legitimate recourse. Someone gets into a relationship, they don't like the person. It could happen in any marriage, a marriage that happens in Canada between 2 Canadian people or 2 Canadian permanent residents. Some marriages work out, some marriages don't work out. For a simple reason, it could be anything. In this particular case, where immigrants are going to be coming in, sponsored spouse, now the sponsoring person in Canada has an extra power towards them. They can say basically, well, I don't like you. Over and above this divorce, I want you to be deported from this country. So that's a bit of an issue that we're dealing with. There are these exceptions. We're going to talk about these one by one. What do these exceptions mean? How do you prove these exceptions? And what are the conditions that we're looking at? So keep in mind, so these are the conditions: 2 years or less in relationship, no child of their own, but they should be, for those 2 years, should be cohabiting in a conjugal relationship. Now we'll dissect this further. How will this regulation be enforced? Let's just quickly talk about this. CIC is the primary enforcing body of this regulation. There is a likelihood of random assessment of couples. Basically, CIC may investigate tips, any kind of anonymous reports. Now, I just want to give you a bit of background information. in terms of complaints and anonymous reports. In CIC lingo, it's called a PPL. It's called a poison pen letter. Essentially, when someone makes a complaint against a particular permanent resident or citizen, or someone who is in Canada, or there is something that there is a reason to believe they have committed a crime against they have committed an act against the Immigration Refugee Protection Act, someone can write a letter. It could be a simple phone call, and it's on the record. It's registered as a PPL, a poison pen letter. And Citizenship Immigration investigates quite a few of these on a yearly basis. So they can, again, investigate that. Remember the background where this is coming from. This is coming from marriages of convenience, fraud marriages. We're trying to control those things. So remember that a lot of genuine relationships may very well fall under that, just because someone made a phone call or wrote a letter. The reason could be any. They may have some sort of an issue going on among themselves. If they write a letter, there is a likelihood. I'm not saying every single poison pen letter or complaint is investigated, but there is a likelihood they may get investigated. Now, CIC may require proof that the sponsor and sponsored person are complying with the 2-year condition. What does that mean? We'll go into detail, but essentially what immigration wants to know, are you cohabiting in a conjugal relationship or not? The condition is recorded in the government computer system, as I mentioned before, at GCMS. Essentially, after the 2 years period are over, if there is no pending investigation, the condition automatically removes from the system. Nothing happens. If there is an investigation going on, the condition stays on until the pending the whatever the outcome of that investigation is. As I said, conditions, what if the condition is not met? The CIC can investigate. The submissions may be made. Now, CIC may, if they're not satisfied with the submissions, the CIC may write an inadmissibility report. We'll discuss that towards the end of the presentation. Now, if the sponsor spouse does not meet the condition of cohabiting in a conjugal relationship with the sponsor during the conditional period, their permanent resident status could be revoked, could be taken away. Okay, so that's an important thing to remember, that those are the consequences. That can also happen to dependent people who came with that sponsored spouse. Now remember, a child may be involved in a marriage, and those kind of things. So that child may also have an impact on that. So it's not just for the sponsored spouse, but also for dependents from that relationship. Now, as I mentioned, there are exceptions, those 2 exceptions. Death of the sponsor, we're not going to go into detail. It's pretty straightforward. If the sponsor has died within the conditional permanent residence period, they could be, you can provide a death certificate. The important thing to remember, though, if citizenship immigration is well within their right, according to this change in law, to ask whether you were cohabiting in a conjugal relationship before the death of the sponsor. So that is important. So it's a 2-stage process. Whenever you're asking, or your clients are asking for an exception, request of an exception, it's a 2-stage process. First is evidence of cohabitation in a conjugal relationship, and then the death ends that. Or if it's the second exception, the abuse and neglect exception, then up until the time the couples were living in a conjugal relationship, cohabiting together, and then because of abuse and neglect, this relationship has ended. So regardless of what exception is sought or asked for, the first part of the test has to be met. So it's important that if someone is in a, so this presentation essentially is focused on the abuse and neglect part of it. So a lot of the information that you'll see in the slides is geared towards that. So just keep that in mind. So if a spouse, a woman is in trouble and is in a difficult situation, she should consider calling with a support person. Always provide contact information which is confidential and will not be intercepted by the perpetrator of the violence. So just keep that in mind. Very, very important. There are guidelines available in Operation Bulletin 480 of CIC, 480, where it says what CIC officers should be following, what sort of protocols they should be following in order to protect the caller or the complainant or whosoever has actually requested an exception to the conditional permanent residence requirement. Now, how to prove cohabitation, how to prove a conjugal relationship, and how to prove abuse and neglect. Very valid questions I see as I'm talking. So we'll go into the details. Now, basically, as you may know, during your work, if you have seen spousal sponsorship application, they in and itself were very intrusive in nature, explaining, where did you go for honeymoon, what happened when you travel, pictures of travel together, telephone conversation, bills, email exchanges. Those things were required to show, and this was for overseas spousal sponsorship. Now these people are not together. I'm talking about the regular spousal sponsorship when it used to happen. That information was there, and it's my opinion that that information was enough to read out any marriages of convenience or fraud marriages, because that system does work. It's where, and if it doesn't, like, so if immigration had a piece of paper, an application in front of them, and if they had questions, they could always arrange an interview, and they have. They regularly, you may know from your work, arrange interviews for the spouses for a spousal sponsorship, and to ask if there are any discrepancy in the application, discrepancy in the documentation. So they do ask those questions. In any event, we now have this to prove cohabitation after the sponsored person has landed in Canada. How do you prove cohabitation? Evidence of cohabitation includes joint bank accounts or credit cards. And you can see from the list, joint ownership of a property, joint residential leases, rental receipts, joint utility accounts, management of household expenditures as a couple, evidence of joint purchases, especially for household items, some big ticket items it could be, correspondence addressed to either or both parties at the same address. So please remember this information is very critical. What kind of information is required to prove cohabitation? Even if a woman is seeking any kind of exception from the application of conditional permanent residence, those conditions for abuse or neglect, the cohabitation in a conjugal relationship has to be proven first. And this will come into, so for example, let me just give you an example. Mind you, this is so new, we haven't seen a case yet. We will probably start seeing cases in next 5 to 6 months. The processing time for New Delhi in China is around 8 months for Beijing and 10 months for New Delhi. Pakistan is at in excess of 20 months, so we may not see those cases at this point. I'm speaking from South Asian perspective, of course. So having this information is very critical to prove evidence of cohabitation, that these two people actually were living together, have lived together, and have a shared understanding of a future together. There is interdependency. They have a common goal, and they're working towards that. So those kind of. So identification document, driver's license, insurance policies. If these important documents, both of them may have driver's license and both of them got delivered at the same address, good proof, of course. Any identification document, both of them, he gets his, just for example purposes, the husband, who is a Canadian citizen, receives his passport in Canada on that address, and the wife, who has landed recently, gets her permanent resident card there, and other documentation over the period of time as well. Shared responsibility for household management. It's a very vague terminology. It comes straight from immigration, so probably showing evidence like how they've been doing things together, or taking turns to how they have basically shared responsibilities. There may be an interview, so they may ask these questions, of course. So there is a likelihood of an interview. That's very important. So regardless if there is an evidence or not, like paper evidence, they may schedule an interview for the spouse. We're specifically talking about exceptions at this point, so it may be just the one party. They may be asked for evidence at this point. while cohabiting means living together continuously from time to time, one or the other partner may have left home for work or business travel. So the separation must be temporary and short. That's very critical. So take this example. A husband is living here but has a a traveling sort of a business, or maybe lives like 6 months here or like 8 months overseas and 4 months here. Those things, they may require more information than just regular stuff. So if they have common joint account, the intention is to be proven. The intention that they have lived together, even if it is they have been separated for a period of time. So just be aware of that. Evidence of a conjugal relationship. Now that's critical. That's the second piece of the puzzle of the cohabitation and in a conjugal relationship. Shared shelter, of course, explaining the sleeping arrangement, behavior. If there is so as you may see, it says in instances where an interview is warranted. So there they may ask these questions, the personal behavior part of it. Services. For example, conduct and habit with respect to the sharing of household chores. They may ask these questions: who does what, how household chores are divided, those kind of. So these are activities. Now, in a typical relationship, there may be certain man-dominated tasks. There are certain women-dominated tasks. I'm not saying I necessarily agree with those, but there are certain things that often are reflected in a particular spousal relationship. In a marriage. So those things would be important. Financial arrangement, ownership of property, again. So kind of like overlaps these things. These are more of a deep, almost like emotional things, vis-a-vis relationship with the person. Is it a committed relationship? What kind of, is it, what kind of those things are? So they're looking at that in terms of a conjugal relationship. The societal perception of the two as a couple. So here, if a letter, like a friend could write a letter, support letter, or an affidavit could suffice, basically saying, yes, they got married, we have had them over for dinners many times. Here are the party pictures. When they got married, we had invited over for that particular ceremony, or like there was a baby shower somewhere, and there are pictures of that. So how have they shown themselves as a couple to the society? Essentially, whenever you're dealing with this kind of situation, you always want to make sure that you're thinking from the point of view of an officer, from an immigration officer. That's what I always tell my clients also, whenever they're putting any kind of application. How do you distinguish your application from a frivolous or a fraud application? And it's straightforward. You just put in the information that's needed, and you just put it straight out. And I think that's very important. It could be uncomfortable, of course, but it's given the climate we are in, I think it's important to have these documentary evidence. It used to be the case where in the previous spousal sponsorship regime, where after the person has landed, after the sponsored spouse has landed, people don't keep any of the documentary evidence. I mean, we still struggle with cases where people actually don't keep documentary evidence even after getting married. And they have come here, and now they're starting the process. They're using calling cards, which is zero evidence of calling someone, basically. From immigration point of view, I can basically pick up calling cards from anywhere, and it could mean nothing. So those kind of things. So now the onus is actually even further. Even after landing, you have to keep those. You have to keep at the back of your mind that I may be asked to produce this evidence, regardless if there is an abuse or not, regardless of that. Because conditional permanent residence applies to everyone. It's only the exceptions where one party is going to be providing the evidence, only that. But in cases, just to give you an example, husband and wife happily married, they have a pretty decent relationship, they respect, care for each other. They may get a phone call because somebody made just a frivolous complaint saying, this is a marriage of convenience, this is a fraud marriage, whereas this couple is living in a totally loving and caring relationship. Now they have to come up with evidence in the last 2 years. Oh, how do we prove cohabitation and conjugal relationship? Keeping those things in mind, being aware of that. It could happen to anyone. Anyone's name could come up and you get a phone call or a letter from immigration. Can you prove to us that you've been living in a conjugal relationship or not? So just being aware of that. how to prove abuse and neglect. That's very important. So this is, again, we're going back to the exceptions. If a spouse is requesting an exception that the condition of conditional permanent residence, those conditions are not applied to me because I've been abused, I've been in the neglecting, this kind of situation. So must provide evidence of abuse and neglect from sponsored person. And as I mentioned, if you recall, it couldn't happen just by calling the 1-800 phone number that you saw in the initial slides, by just making that phone call. From sponsored person, the abuse must happen from the sponsored person or from any other relative of the sponsored person. It can't be some random person. That's very critical to remember. Evidence could be from shelter. So that's where a lot of organizations that you might be representing today, your information will come in handy. Make sure when you do an initial intake, have all the information, encourage your client to keep documentary evidence in a safe place. Maybe, I don't know what you suggest, if you have a protocol to follow, so that they have evidence, they have documentary evidence to prove cohabitation and then subsequent abuse. It's very important that this exception can be invoked only after the relationship has ended because of abuse or neglect. That's very critical. Must provide evidence of conjugal cohabitation with sponsor until it stopped because of abuse and neglect. That's very critical. We're yet to see how this will play out in terms of actual application of the law. So we're kind of waiting on in terms of how they will treat it. Can a spouse make a phone call while the husband is away for work and say, look, you know, my life is in danger, or like it's really difficult, I can't live here, can you remove the conditions? They may take that information in consideration. I can't give you a straightforward answer to that at this point in time. So information and evidence can be provided by these four means, of course. They may also schedule an interview, as I pointed that out at the earlier part of the presentation. Evidence must show abuse or neglect as was the reason for breakdown of relationship. Now that's kind of, it's very subjective. As you know, abuse is subjective and understanding of abuse is subjective. Different people, different communities, different cultural groups, different individuals look at it differently. So, and you representing a very myriad of agencies and groups that you serve, you may know for one of the groups would constitute the end of the relationship because of abuse or neglect, or for someone like, no, this is totally acceptable to this point, and then there's an end of relationship. It varies. The critical thing is it's documented. I think that's the important part. And I again want to highlight this: must leave the relationship at home before requesting the exception from abuse and neglect. Now that's what the guidelines say. I'm pretty sure that there will be cases where the abused partner or the spouse would be calling while they're still in an abusive situation, and we're not sure at this point how that will be taken into consideration. Now, the fourth point on this slide is very critical. Any information of abuse to or witnessed by a child may be reported by CIC to child protection authorities or police with or without the mother's consent. Very important factor. Again, a lot of our communities that we serve are affected by this as it is. Now there is another a straw on that. There could be, I mean, it's a good thing, but it's important to remember that mother's consent is not required in these kind of cases. So just be aware of that. Now, what happens if the exception because of abuse and neglect has been requested by the sponsored spouse is denied? Now, what happens under sections 44? An inadmissibility report is generated. Now, an inadmissibility report is basically saying the officer will say, well, I looked at all the evidence that was before me for this conditional permanent residence matter, and I'm not satisfied with the responses and with the evidence before me, and I believe that this individual is inadmissible and is in contravention of the Immigration Refugee Protection Act. and should be removed from Canada, or like there should be proceeding. What happens to that? You challenge that. You take it to the Immigration Division of the Immigration Refugee Board. Now, it's imperative that they have a lawyer for these matters. I think it's very critical to have evidence submitted for these appeals. And it's very, very important that all the documentary evidence is available at the disposal of the appellant, so that can be proved in front of the ID at the Immigration Refugee Board in order to alter the judgment of the officer. Okay. What if deportation is ordered? If the ID doesn't agree, they basically issue a deportation order. After the inadmissibility hearing, it goes to the ID. After the ID basically refuses the matter and says, no, you should be deported, you go to the Immigration Appeal Division of the IRB again. Now, in cases with our kids involved, of course, under the age of 18, best interests of the child could be used as an H&C ground. How it will impact. So keep those things in mind. Like if someone is coming to you, they have a child, but they are also in the conditional permanent resident conditions, be aware of having a child in that, because that might have an impact on the outcome of the case. If sponsored person's appeal is unsuccessful, they can ask for a federal court to judicially review the decision. Of course, goes without saying, getting a lawyer to represent is absolutely critical in these sort of hearings. The sooner a legal person gets involved, the better it is. I think that's the focus that I want to put in. It's very critical that a legal person, lawyer, gets involved at the right stage. If you're not sure about something, call in your areas, or if you have connections in your own network, call those lawyers. Call a legal clinic who practices an immigration law. You can call me, of course, as well, to get some information. I think it's very important to have evidence, because immigration is basically moving towards removing this person. Evidence and the mostly documentary evidence are mostly stacked against the individual. The onus is only on the applicant, only on the person who requested the exception to satisfy immigration. And given the climate we're in, they're moving really fast on any kind of deportation, any kind of removal order. So we know how the system is working. The system is working to make sure that people are deported as quickly as possible, as we've seen in the refugee law, the changes in the refugee law. So just be aware of that. I think that's very important. Now, the second piece of this, the conditional permanent residence part of it, is also a 5-year bar on spousal sponsorship for previously sponsored spouses. Now, that is a very it's basically a very difficult situation. Essentially, again, the idea that the government has served is to deter people who have managed to come here on a false marriage or a marriage of convenience, so that they are, even if they got sponsored and became a permanent resident, they cannot sponsor someone for a period of 5 years from the date they land. So just quickly read through the effect, and that has already come into effect on March 2nd, 2012. Section 130 of the IRPR. This amendment bars the previously sponsored spouse or partner from sponsoring a new spouse or partner within 5 years of becoming a PR, even if the sponsor acquired citizenship during that period. Pay attention to that. It's very critical. It doesn't matter if someone became a Canadian citizen. They would still be under the 5-year sponsorship bar. Only for spouses. Other members of the family class are not affected by these regulatory changes. So they can sponsor if and when the parental sponsorship gets opened up. Only immigration knows when that's going to open up. Now, this is just an illustration that I picked up from the government website, the CIC. So as you can see, the landing in Canada part, the arrow is and that's when the conditional permanent residence is in effect. The 2-year removal of condition from permanent resident status, given everything is fine, no investigation, nothing happens, it automatically gets removed in the second year. Third year, sponsor undertaking to sponsored spouse ends. Now, this is very important. Some of you may have asked this question. Now, if a neglect is proven, does the sponsor's obligation to for the sponsor, does that end? It doesn't. That's a very critical part of it to remember. If you are talking to a sponsor, if someone asks you that question, the sponsorship undertaking doesn't end. It doesn't matter if these people are living together or not. It stays as it is, how it was before. People, they got sponsored, they landed in Canada, and after a period of, say, 6 months, they had a fight, or like a 1 year, they separated and then subsequently got divorced in the second year. The sponsor will still be required for the sponsorship undertaking for the estranged spouse for a period of 3 years from the date of the landing. So that's very important. Now, the 5-year bar against the sponsored spouse, sponsoring a new spouse ends. That's the 5th year. All right. So these are some of the resources. Go through these at your own pace. They are mostly from another webinar that was provided by Your Legal Rights, what sponsored spouse needs to know. Some of the resources, excellent resources here. Now, it's open for questions. We'll take up questions from the side panel. Yes, we only serve the South Asian population. So the question was, do you only serve the South Asian population? Yes, as a mandate given to us by Legal Aid Ontario, we can only serve South Asian population in the Greater Toronto area. But we don't hesitate on providing advice and information regardless of the client's background. And so feel free to give us a call. If we are available, we'll definitely get back to you. How do you prove the relationship is conjugal? As I pointed out in the slides, what kind of proof of cohabitation can CIC ask for? Again, going back to the slides, you get that information. I would also encourage, because you guys will see quite a few of clients in this, I strongly encourage everyone to actually look at Operation Bulletin 480. It was released on October 26, 2012. You can find it on CIC website. And we'll put the link online, and then you can take a look at it after the presentation, okay? And this has a very comprehensive list of information that the government is looking for. Of course, it's not exhaustive, and you can just go through it. And if you're in doubt, definitely call a lawyer, okay? What happens when, okay, that's if the child was born in Canada, would their citizenship be revoked? Of course not. If a child is born in Canada, their citizenship will not be impacted by this, because they're not on the conditional permanent residence. It's only for permanent residents. How can we prove mental or psychological abuse, since there won't necessarily be any hard evidence? Really good question. Again, I guess you as service providers might come in really handy in that situation. A report from a specialist if the spouse is seeing a doctor. I think going to a doctor, going to a community health clinic, going to a settlement agency, speaking to a settlement worker, having that evidence and having that documented and sent to CIC on an affidavit or a support letter should suffice at this point in time. And of course, if you have a psychiatric, not evaluation, but like if someone is seeing a psychiatrist for depression or even seeing a psychologist for counseling purposes, that should be able to assist. But you're right to point out psychological and mental abuse is actually really difficult to prove. Must leave both the relationship or that's a really good question. Again, as I said, it's yet to see, but the directions are clear that the person must leave the relationship and home. The relationship must have come to an end because of abuse and neglect. So that's what they're focusing on. Will legal aid provide a certificate for these matters? I'm not too sure. Given the situation we're in right now, legal aid has already pulled its hand from the refugee side of certificate in immigration. and it's very unfortunate. So I'm not too sure where legal aid will be on this one. At this point in time, I do not have information on that. If there is a merit on the case, if there are exceptional circumstances, I believe legal aid would be willing to provide a certificate, but that probably would be require some advocacy to get that certificate. What if the couple did not have children at the time of that the sponsored spouse arrives in Canada, but later have children? Are the condition annulled as soon as the women fall pregnant or have children? No. If the person has landed without a child, the condition stays. If at the time of landing there is a child, the condition doesn't apply. Now that's why a lot of, and I've heard this from a lot of corners where I do public legal education, there is people are being encouraged to actually have a child and then do the spousal sponsorship, because in a lot of cases it already takes, as I gave you an example of Pakistan, it already takes 22 months to get the spousal sponsorship process, which I'm talking about a routine spousal sponsorship. So people are basically saying, look, I mean, have a child right in the first year of the relationship, then put the spousal sponsorship in, and there will be no conditions attached to it. For the 5-year bar on spousal sponsorship, is there an exception for cases where the sponsor died shortly after the sponsored? Yes, so again, that's a really good question. This will fall under an exception, right? The exception includes the abuse and neglect and the death of the sponsor, but that has to be applied. That has to be requested. The immigration is not going to know any of this stuff. They need to be informed of this development, that the conditions should not be applied to me as a sponsored spouse because of either the death of the sponsor, died, and like then you provide all the evidence of cohabitation and conjugal relationship right before the death of the sponsor, and or if it's an abuse and neglect, then you explain the situation of abuse and neglect in terms of evidence. If the sponsored spouse arrived before March 2012, does the 5-year bar apply? No. It's the date that we mentioned on the list that would apply. So if a sponsored spouse is approved for an exception because of abuse and is allowed to remain in Canada, and even though the 2 years has not passed, is the sponsoring spouse still responsible for financially supporting the sponsored spouse until the 3-year period is over? Yes, even though the relationship breakdown. So it doesn't matter if there is a relationship breakdown. It could be a divorce. It could be everything. It doesn't matter. The sponsoring spouse is responsible for the duration, the 3-year duration of for the sponsored spouse. So it doesn't change anything. What happens to the spouse that leaves an abusive relationship but can't prove it? Would this lead to automatic failure to have complied with the requirement of conjugal cohabitation? Seems like a catch-22. Okay. Would this lead to automatic failure to have complied with the requirement of? Well, I'm not sure what you mean by that, but I guess what I understand from this, if a spouse that leaves an abusive relationship but can't prove it, well, I mean, then that's a difficult place to be in. There must be some indicators of leaving the relationship, and from those indicators there must be some evidence that must be coming out in terms of why this person left, what was going on in the relationship, anything that this person is narrating to. Then that's where I think a lot of us will come into play. If you probably are the first point of contact for a lot of clients, and I think if the evidence have already been gathered, or at least have started to be gathered, I think that is critical. And I think in a lot of situations, and the issue will be, and I can actually see this happening in a lot of, for lack of a better word, I would say typical relationship, I guess typical male-dominated relationship, if I may. Women actually won't have any sort of these documents that they're looking for, rental lease agreement in her name, in any joint bank accounts, any kind of joint credit cards, any kind of joint property ownership. I don't think those things are going to be there. I think there has to be more information to that, and I think that's where the narratives are going to come in handy from the workers and from the what you call it, like the doctors or the community health clinics or settlement workers. And I think that it is a bit of an issue, of course. How short is short? For temporary travel absence, if someone works as a truck driver or someone works in Alberta or only comes home once every few months, is this okay? Or the sponsored person is at risk of losing PR? Well, good question. I believe you can prove this if it's a truck driver, like just looking at your example. I think truck driver example would work because you can easily prove this person is a truck driver and this is what their hours are, and this is how they travel, this is how much they're out of the country. I don't think there is a set limit for how short is short and how long is long that will jeopardize someone's permanent resident status. I believe when this kind of situation will happen, there will be other evidence of conjugal relationship, of cohabitation together. They may also be going together somewhere, traveling within Canada, or like whenever the husband or the partner is visiting them, they might be doing some other activities, going to other parties. Those kind of things will be, I think, helpful in satisfying the immigration of those. If the sponsor and the sponsored spouse have a relationship for 2 years and they adopt a child, can the conditional be removed? Yes, if they have it before the conditional, it doesn't remove, it doesn't apply. But nothing happens after the landing. Anything happens, you can have a child or adopt a child, both of them, it doesn't matter. Anything before that, they won't have the condition. Someone who have just arrived in December 2012 and got separated in January 20 would be subjected to this new regulation? No, not the conditional permanent residence part. But again, just remember one thing. I just want to point this out. When I was talking about the complaints to CIC, the poison pen letter part of it, be aware this is happening. As we speak, a lot of people are basically just doing that. There are now so-called self-vigilante groups who have access to the internet. They have websites and stuff, and people, as soon as, like, say for example, I sponsored my wife and now I'm bitter about something and I don't want to continue the relationship, and she just landed, like, say, assuming she's on conditional permanent resident, now I'm looking for ways to get back at her. Like, I don't want to continue the relationship. I can find those groups and they will walk me through to write a poison pen letter against my estranged wife to get her out of the country, or at least make life difficult for her. It's very important to kind of keep that in mind. Alrighty, we're out of time. So thank you so very much, guys. I really appreciate your time. And if you have any other questions, go to our website, www.salc.on.ca. and look us up, give us a call, feel free to provide a feedback on this. And so again, thank you very much.
Okay, thank you everyone for being part of this webinar. We will try to post the file as soon as it becomes available. So we are hoping by tomorrow, but at the very least by the end of this week. And we saw a lot of questions about the slides. So we'll post the slides by tomorrow morning. Take a look at the OCASI website for the slides. And for the questions that didn't get answered, we'll ask Atulya, we'll beg his indulgence, send in those questions and get those answers, and we'll post those as well. So thank you again.